Good evening, everyone. My name is Mohammad Qasim, student of BLLB fourth year at Muhammad Ali Johar University, Johar Nagar, Rampur, UP. Today, I will be presenting on a very crucial and practical concept under property law, lease, lease, section 105 of Transfer of Property Act 1882. From renting a house to leasing commercial spaces, leases are a part of our everyday lives. In this presentation, we will explore what makes a lease valid, what rights and liabilities it creates, and the law protect both lesser and the lessee. Without much wasting of our time, let's proceed to the concept. Basically, section 105, 106, 107, and 111 of Transfer of Property Acts, Property Act 1882 deals with the concept of lease. Today, we will study section 105 of Transfer of Property Act, lease and license. In general terms, what is lease? In general terms, lease can be defined as the right to enjoy any immovable property for certain time by the lessee, and that right is given by the lesser to the lessee. Section 105 of Transfer of basically Section 105 of Transfer of Property Act deals with the concept of deals with the concept and definition of the lease. It defines lease as the transfer of right to enjoyment of such immovable property for certain time, and expressed it may be expressed or implied, or it can also be in perpetuity. Perpetuity means for indefinite period of time, and it must also be and it must be in consideration of we had already studied about the consideration. Basically, section 2D of ICA is with the definition of consideration. Under section 105 of Transfer of Property Act, consideration may be price paid or promised. It can also be money. It can also be share crops. It can also be a service or any other thing a value to be rendered periodically on a specific occasion to the transferor by the transferring. The parties involved in definition are defined as follows. Number one, lesser. Number second, lessee. Number third, premium. Number fourth, rent. Now the question arises, who is lesser? The transferor who grants the lease. The person who grants the lease is the lesser. Third is, who is lessee? The transferee who receives the lease is known as the transferee. Third is the premium. The price paid for the lease is the premium. Fourth is the rent. The periodic payment made by the lessor to lessee is known as the rent. Mr. X, let's take one example that Mr. X lease Mr. X lease property by to Mr. W. Mr. W. Here X is the lessor and W is the lessee. The periodic payment done by the periodic payment done by W to X. W to X is the at X shall be rent. Now proceeding further, from the definition of lease under section 105 Transfer of Property Act, we extract some essential elements. The first essential element is immovable property. The property must be immovable. That is, the subject of the lease must be immovable property. It is defined under definition clause of Transfer of Property Act. Second is the transfer of right to enjoy the property. Here, the transfer of right to enjoy the property means the lessor shall transfers only right to enjoyment of the property to the lessee. If ownership is transferred, then it will become sale. This is the basic difference between lease and sale. Under the concept of lease, the right to enjoyment of the property is transferred, whereas under the concept of the sale, the ownership is transferred from seller to buyer. Third is for a certain time or in perpetuity. The lease can either be for the fixed duration or for an indefinite period of time. Here, fixed duration means it may be for 11 months. It may also be for 5 years, 2 years, 3 years. That is the fixed duration. Or in perpetuity, in indefinite time means for perpetuity that there is not any fixed time. Fourth point is acceptance by the transferee. Every formality has been performed now. The acceptance of the transferee, that is the lessee, must also be needed for the lease. Here, the acceptance can also be implied. Acceptance can also be implied, or it can also be expressed. Expressed means by in way of writing or anything, etc. And implied by way of conduct or anything or any other same means. It can also be considered as the acceptance. Fifth point is parties competent to contract. Here, parties must be competent to contract in accordance of ICA 1872, that is Indian Contract Act 1872. The parties must be the parties must be competent to contract. Sixth point is consideration, that is the rent. The lessee must pay rent in form of consideration, as I already told. Section 2D of ICA deals with the consideration. This is the definition of the consideration. The consideration can also be the consideration can also be present, or it can also be future. It can also be present. It can also be future. Future. Moving further, no transfer of ownership. I already told there shall not be a transfer of ownership. Unlike sale, a lease only transfers the right to use the property, not ownership. If ownership is transferred, it will become sale. If right to enjoyment, if right to enjoyment is transferred, then it will. If right to enjoyment is transferred, then it will be said as lease. Proceeding further, types of lease under Section 105 of Transfer of Property Act. Number one is fixed term lease. As I already explained earlier, fixed time leases are for the specific duration. They are for the specific duration lease, like for 2 years, 11 months, that's all. Second is periodic lease, that is month to month or year to year lease. These kinds of lease basically renews automatically. They get renews automatically at the end of each period unless terminated by the notice. The main thing or the main crux is that these kinds of leases are automatically terminated at the end of each period. Says lease in perpetuity, that is for the indefinite period of time. Indefinite period of time. These leases with no fixed end date. These kinds of leases have no fixed date, but it must comply with Section 105 of Transfer of Property Act. It shall, for example, a lease, here the example is already given. A lease where rent is paid indefinitely unless terminated as per the agreements. Now moving further, rights of the lessor. The first right of the lessor is claim rent. As we already studied earlier, that the rights of one party are the duties of another party. Here, the rights of the lessor are given as number one to claim rent. The lessor is free to claim rent because his property is his property is leased. Second, recovery of property at the termination upon the termination of the lease or the end of the lease term, the lessor can reclaim the possession of the property if lessee declines to return the possession, then then the lessor can file the suit of suit of eviction can be filed by the lessor. Third is the damages recovery. The lessor can also claim compensation for any damage caused to the property if the lessee if the lessee damaged property, leased property, like damage the wall, any furniture which is given by the lessor, doors, windows, fans, etc., then in such conditions lessor can claim the compensation. Lessor can claim the compensation from the lessee. Fourth is the sue for eviction. The lessor can also sue lessee for the eviction, as I already explained this point. Liabilities of the lessor. Number one, the first liability of the lessor is to disclose the material defects in the property. If there exists any kind of material defect in the property, then lessor must disclose the material defect in that in such property, in that particular property. Second is the to pay government taxes unless agreed otherwise, means it is the duty of the lessor to pay the government taxes unless any provision in the lease agreement, in the rent agreement or the lease agreement contains this provision, unless agreed otherwise. Third is the to maintain the property in habitable condition unless the lease states otherwise. It is the duty of each and every lessee to maintain the property in habitable condition. In habitable condition. Moving further to the rights of the lessee. Number first is the first right of lessee is to enjoy peaceful possession. To enjoy peaceful possession during the lease term. No one can interfere in the lessee's right to peaceful possession. Second is the to assign or sublet unless restricted by the lease agreement, to make necessary repairs and deduct cost from rent if lessor refuses. It is the right of the lessee to make any necessary repair in that particular property, and the lessee shall be free or independent to deduct the cost of the payment from the rent. For example, the rent the monthly rent of property X is 15,000 rupees. Lessee performed 5,000. Lessee spent 5,000 rupees in repair. Then lessee can only give give 10,000 rupees only to lessor. Can deduct 5,000 as the as the cost for the repair. Moving further, liabilities of the lessee. The first liability of lessee is to pay the rent on time. The rent must be paid by the lessee on time. Second, to use property only for the agreed purpose. What does here this agreed purpose means? Means if a property is for residential purpose, then he must use it as residential purpose only, not as commercial purpose. If it is used as commercial purpose, then lesser is free to take any action against the lessee. Third point is to not commit waste. To not commit waste. It is the liability of the lessee not to damage the property. Moving further, and most important subtopic, that is determination of lease. Basically, section 111 of TPA deals with the determination of lease. Determination means termination of lease means termination. Determination means termination means खत्म कर देना. There are total six conditions given under section 111 to terminate the lease. Number one, expiry of fixed term. As I already told, if fixed term is expired, then lease shall be automatically terminated if it is not renewed. Second is notice to quit for periodic leases. If lease is if a lease is for any specific period, then after giving you notice, they can quit and lease can be terminated. Third is the surrender. Third is the surrender. It is the mutual agreement to end the lease. It is the mutual agreement to end the lease. Fourth is the forfeiture. If breach of forfeiture is the another forfeiture is the another. Fifth is the merger. If lessees acquire ownership, then it can leads to merge. It can leads to merge. Sixth is the destruction of the property. If property becomes unusable, destruction of the property. If the subject if the property which is leased has been destructed by any natural calamity, or by or even by the government, then the lease can automatically be terminated. Last subtopic is last our last caption is registration and stamp duty requirement. If lease is for greater than 1 year, then it must be registered under Registration Act 1908. Why it must be it why it must need to be registered? Because registration gives the rights and liabilities to the lessor and lessee. We can also bring action against each party, against the each parties can also bring action against each other in court of law. Second is the if lease is for less than 1 year, then registration is optional but advisable. Fifth is stamp duty. Stamp duty must be paid as per the state law. Stamp duty must be paid as per the state law. To sum up, a lease is not just a simple renting agreement. It's a legally recognized interest in immovable property that creates enforceable rights and obligations. Section 105, 106, 107, and 111 of Transfer of Property Act basically deals with the concept of lease. We already knows that possession is nine tenth of the law, but the lease defines the tenth. Thank you for your